Domestic workers are urging President Cyril Ramaphosa to sign the compensation bill into law. The legislation, which was sent to the President more than 2 months ago, if signed into law, will allow domestic workers to claim compensation for work injuries. For more on this, I'm joined by Nokuthula Sihlangu, Claims Director of the Compensation Fund. Nokuthula, very good afternoon. Now walk us through what changes this will have for domestic workers if signed into law.
Good day, Hugo, and good day to your listeners. Thank you for having me. So what this means is that the domestic workers will gain access to all benefits that all employees are able to access. And this has already been effected by the Constitutional Court order that was passed in 2020 already, where we already given access to domestic workers from the year 1994. So that means that if they're injured, they'll be paid for being off sick as a result of injury on duty. They'll be paid many other benefits like your fatal benefits that are accessible to dependents of deceased employees as a result of injury on duty. And many other benefits. Some of our beneficiaries or our injured employees are even getting monthly pension for the rest of their lives. So these are some of the benefits that domestic workers were not having access to before this court judgment, as well as signing this into law.
Now, the court order was made retrospective to 1994. Do you expect, or have you had a huge influx of claims?
Definitely. I expect that because the domestic worker sector is a high-risk industry. They have a high risk to injuries. If you think about it, they have to cook, they have to iron, they have to clean, they have to climb ladders, and so on. Some operate dangerous equipment in the garden. All of those things expose them to the risk of injury. I believe the same applies to occupational diseases when they are looking after children of their employers as well, who may have COVID-19 and any other disease that is contagious. They may be exposed. So for me, they are high risk. I expected a high number of claims to come through or a high volume of inquiries just to ask how can I access benefits. But we're not seeing this, Hugo. We've got very few clients that are coming through to ask access to benefits, and that is way lower than what we anticipated.
I'd imagine that there's a huge amount of advocacy that needs to be carried out to create the necessary awareness. Do you have plans for this? Is this currently happening?
Definitely. We started immediately before the Constitutional Court made that decision, because remember, the lower courts had already made that decision. We were just waiting for the Constitutional Court to ratify that decision. And we've been talking to using different platforms to gain access to domestic workers and employees. But we've realized that these employers and employees are not easily accessible, because come to think of it, domestic employers are also employees in other institutions. So by the time we're talking to them, they also at work doing other businesses for their employers. So we need to employ different mechanisms. I believe the mechanisms that we're using right now are not assisting us to reach out to domestic employers and employees. I was exposed to one incident where I was speaking with domestic workers, and by the time I finished the presentation, half the hall was empty, because this is a vulnerable sector. Should they miss an hour of their work, they lose their money. So they had to leave, even if the advocacy session was important to them. So we need to find a mechanism that is different from any other that will assist us to reach out to the employers and employees in the domestic sector.
Isn't it possible that the employers are likely to be reluctant because they fear being liable for any injuries or claims that may arise from injury or death on their premises?
Definitely, they are liable. Remember, the employers are the only policy holders in the compensation fund space, unlike the UIF, where you have the employer and the employee contributing. But what I want employers to be aware of is that we expect them to pay premiums from November 2020. not from 1994 April. They're not paying retrospectively, but they're paying prospectively from the date of that court order. So what that means is that they're paying a small amount of money. And the other thing that they should be aware of is that we've got a minimum a premium or assessment for domestic employers. That is a small amount of 491 rand. So you can imagine that's a premium that they pay annually. They're not paying that figure monthly, but by them not paying and registering and not reporting accidents, they're robbing their employees of access to medical aid and all those benefits that I've mentioned already.
So what are the rights of the domestic worker if your employer does not contribute to this fund? Is there an option for a domestic worker to contribute themselves directly?
No, they don't contribute directly, but that doesn't mean that we won't consider their claim. So there are many other claims that we become aware of when the domestic worker knocks at the Department of Employment and Labour doors. We've got forms that they complete and submit to us, and those forms assist us to start with a claim while we're chasing the employer. And I want them to be aware that while we're chasing an employer, we won't put the claim on hold, but we have mechanisms to register such a claim and adjudicate on it. And once we have the employer located and linked to the claim, we have a complete claim. So our desire as the compensation fund is that injured employees must gain access to medical treatment as soon as they get injured, because we understand that if there is a delay to getting access to treatment, the chances of restoring the person to their ability to do the same function may be compromised.
Now, a significant number of domestic workers are foreign nationals who may not be documented. What happens in this instance if I put in a claim on behalf of my domestic worker who isn't documented? Are they able to receive compensation of some sort?
It must be clear that a domestic worker needs a valid identity document, whether it's a passport or it's a work permit or asylum seekers document. They need a valid identity document. So even if they're not registered as a work seeker, our COID Act compels us to treat them as an employee, but we won't treat them as an employee if they don't have a valid identity document. I want to encourage them that whatever valid identity document they have, they must present it to us. They should not worry about only having a valid work permit, but they should worry about having a valid identity document. And then we'll register the claim and proceed. We don't register claims for people who cannot be identified, Hugo. And that must be made clear. We only register claims for people who have valid identity documentation.
Okay, that's pretty clear. Now, as we said earlier, the compensation bill has been sitting with the President for the last 60 days. Do you expect any movement in the near future?
Definitely. We understand that the bill has gone through all processes of Parliament, and all we're waiting for is for the President to sign it off. And that can happen any time before Parliament go on recess or as soon as Parliament reconvenes in the new year. But we don't expect any setback at all. It's just a matter of it getting to the President's desk.
Nokuthula Sihlangu, Claims Director, Compensation Fund. Appreciate your time this afternoon. Well, more of your